In 2005, President Bush faced the rare opportunity to appoint 2 Supreme Court justices at the same time. Historical courts of this country have been insulated. We do not look beyond our borders for precedents. Sandra Day O'Connor.
Speculation about who President Bush would nominate to succeed Justice O'Connor was a hot topic following the Roberts confirmation. Bush chose Samuel A. Alito, Jr. Considered a conservative, reaction was again divided among party lines. Alito's confirmation went to a full Senate vote. Alito was confirmed by the Senate on January 31, 2006, by a 58 to 42
Many
vote.
liberals were concerned that 2 conservatives were joining the court. President Bush initially nominated John G. Roberts, Jr. to replace Justice O'Connor. Bush decided Roberts would make a strong Chief Justice. He was then confirmed by a full Senate vote of 78 to 22 on September 29, 2005, making him the 17th Chief Justice of the Supreme Court.
During President Bush's 2 terms, the Supreme Court faced several key issues, including affirmative action and gun rights. Among others, in the June 2003 case, Gratz v. Bollinger, the Supreme Court addressed whether the University of Michigan's undergraduate admission policy was constitutional. The policy was based on a point system that automatically gave 20 points to members of unrepresented ethnic groups. The opinion written by Chief Justice Rehnquist explained that the point system was not narrowly tailored enough to achieve the university's diversity objectives and, as a result, violates the Equal Protection Clause of the 14th Amendment. It is always possible for the court to overreach its proper bounds and perhaps declare a lot of laws unconstitutional and frustrate the will of the majority in any way that it ought to be frustrated. William Rehnquist.
Another significant case during the Bush administration was D.C. v. Heller, a case that challenged the constitutionality of the District of Columbia's Firearms Control Regulations Act of 1975. The D.C. law banned private citizens from owning guns except in cases where the guns were registered before 1976. Those who had guns in their homes were required to store them unloaded, disassembled, or bound by a trigger, lock, or similar device. The requirements rendered the guns useless for the purpose of self-defense. In June 2008, the Supreme Court determined that 2 provisions of the Act were unconstitutional.
Judges and justices are servants of the law, not the other way around. Judges are like umpires. Umpires don't make the rules, and I will remember that it's my job to call balls and strikes and not to pitch or bat. John G. Roberts, Jr.